Okay, welcome back everyone. Good afternoon. I hope you've all had an opportunity to get some lunch and have a break from our sessions. As I mentioned, we didn't quite finish all of our scenarios from this morning, so let's complete those so that we've got a full picture of our critical core day. So where did we get to? We got to scenario 4, didn't we? So this is our breach of bail. It's a breach of Crown Court bail. I don't know, can we do breaches of Crown Court bail? Yeah. Okay. So what is the correct way to deal with a breach of bail, particularly looking at the need to give evidence on oath, the test, and does it make any difference if it is Crown Court bail? So what do we need to do?
So I said the first question, the evidence have to be on oath, and on the second question, the test is the court is of opinion that he has breached or not, and the third question we answered no.
Okay. So just with breach of bail, if we take a tiny step back, in terms of breach of bail, it might actually be that the defendant admits the breach, and so actually they'll come into court and the breach, you'll identify them in the same way as you would any other type of case, and then you would put the breach of bail to them. So you would say, you know, it'll be written out like a charge is written for you. So it might say something like, having been released on bail from Margate, sorry, this is a Crown Court, isn't it? So Maidstone Crown Court with the following conditions: reporting to the police station Monday, Wednesday and Friday, observing a curfew between whatever hours. However, the breach is that you have failed to report to the police station on this date, and the date will be, it won't just be like on a Monday, the date will actually be put for you, so it might be on the 9th of September. And then you'll say to them, do you admit that or do you deny it? Because it's not a guilty or not guilty, because it's not an offence. So you're always going to say, do you admit it or do you deny it? If they admit it, that's like the equivalent of pleading guilty. If they deny it, that's when we move into a breach of bail, like mini trial. So you will only need to look at the magistrates will only have to consider the denial if they don't accept it. So it might be that they admit it, so you're back in that position where the court is in a position where they can then reconsider the bail position, which might be that you're being given conditional bail, or prosecution might ask the court to consider a remand in custody, and the court might agree with that, and you might be remanded in custody. So that's the kind of scenario that you are looking at. Like you've properly answered those questions. What case did we mention this morning? Which is the case that lays out the procedure for a denial?
Liverpool something, City Justice.
Liverpool City Justices, yeah, that's the one. And like I said before, the footnotes of Stones are really helpful, because it's, and again, read it in the book, because I think it's just easier for you to kind of look at. So basically, yeah, there's the footnotes in Stones is they actually talk about there's no requirement for somebody to give evidence on oath. So there isn't any requirement in relation to that. Of course, we've already talked about there's no power to adjourn the case for that mini trial. You have to deal with it, and the prosecution present the evidence that they have at that point. And if it's good enough, then the magistrates will find it proved. If it's insufficient, then they will say they're not satisfied. They're not of the opinion that the breach is proved. What about the the situation we find ourselves here. So this is Crown Court bail. So does that make any difference if you're in the magistrates' court? No.
No, we
No.
hear all that, which is the magistrates court imposed and
Yeah.
Crown Court being imposed.
Yeah, and it doesn't matter what day of the week it is. If you're doing an occasional court on a Saturday or a bank holiday, or if you're here on a Wednesday, all breaches of bail come to the most local magistrates court to where that person is arrested. So even if you've got the Crown Court sitting, they don't go to the Crown Court. They all have to come to the magistrates court. What happens if, say, in this example, the magistrates say, yes, we are of the opinion that the breach is proved. What happens? When's the next date of hearing?
So we were trying to look into the legislation for that. There is actually no exactly provision that says it has to be within a certain amount of hours. It has to be, so in that moment, the magistrates have to decide if they're gonna grant him bail again on the same conditions or not. And usually magistrates courts, they don't vary the bail conditions imposed by the Crown Court.
Yeah.
And then the next hearing for him will be, if he has, for example, a booked in a trial date in the Crown Court, we would just remand him until that trial date. Yes.
But if he was remanded in custody, would you fix a date soon at the Crown Court?
Yes, if he's in custody, I think it would be as soon as possible, so probably the next following day.
Yeah, so I think either if you're on a working week, I'd probably say the next day or the day after. If say you're a Saturday, I'd probably say maybe go to the Tuesday, because there'll be no one at the Crown Court to receive your email about the case or anything, so they're not going to pick it up. No one's going to pick it up until Monday, and if that defendant arrives in custody on Monday and nobody knows why they're there, it just creates a bit of confusion. So you're better off in those circumstances going over to the Tuesday, and then everyone's ready to receive the case and get it listed in an appropriate court and work it out from there. So so that's exactly right. So it's just really, again, with breach of bail, it's just remembering it's not an offence, so there is no penalty. Do not let the bench try and impose a penalty, because there isn't one. It's just an opportunity to reevaluate the bail position. And just remember, the 24-hour clock is really important. You've got to know what time your breach is due to expire, and just kind of organise your court list around that, and get your usher to help you, get your list caller to go and look for the representative, and do some of those tasks for you, because you've still got to run your own court, haven't you? So you can't just dedicate your entire attention to doing that, but just be aware of that you need to prioritise. I mean, obviously all custody cases take priority, but it's a priority within a priority, I suppose, that needs to be dealt with. But do have a look for the JCS guidance as well on breach of bail, and what in relation to kind of going slightly over the 24 hours, and have a read of that. Okay, our last case, so it's our last case represented by the duty solicitor, and you've got a Crown Court bench warrant. So what's that all about? What powers, do the magistrates have any powers to deal with it?
Yes, I think it's on section 43A of Magistrates Court Act.
Yeah, that's absolutely right. So what is a Crown Court bench warrant?
Crown Court issued a warrant.
Yeah, basically, yeah. It's basically the Crown Court's version of a warrant for failing to appear. So it's a fail to appear warrant, and they issue them in the same way that the magistrates' courts do. As you say, section 43 of the Magistrates' Courts Act, and what does that section say in terms of how the court deals with the case? Can the court bail that person, or must they remand them back to the Crown Court?
We can do both.
Go on.
No, I think they can do both. They have the power to do both.
They do have the power to do both, and that's in section 43 of the Magistrates Courts Act. It says the Magistrates Court shall commit him in custody or release him on bail until he can be brought or appear before the Crown Court at a time and place appointed. So basically, you can. I think your bench needs to kind of be mindful in terms of granting bail. They still need to apply kind of like the exceptions to bail and all of those kinds of things. But yet they can bail somebody. I mean, some people say, well, it's the Crown Court's warrant, so they didn't appear. They should go back to the Crown Court in custody. But I think you have to be, you have to listen to the reasons why a defendant didn't turn up, and the magistrates kind of have a think about that, think about proportionality and necessity, and think about those kinds of things. It's about just applying the legislation properly, and making a decision. Can that person safely be given bail conditions to ensure that they're going to attend the Crown Court? And again, with bench warrants, I think what you need to do is you need to list them back at the Crown Court pretty sharpish. So within the next couple of days, if in custody, as soon as possible. If they're on bail, because again, the Crown Court will want to deal with the Bail Act offence. We won't deal with it. We won't deal with any kind of Bail Act offence. We're literally kind of facilitating getting that case back. So we don't look at any kind of failing to surrender or anything like that. You might hear an explanation which will assist the magistrates in making the decision whether or not to bail or remand. But like we would with a Section 6 failing to surrender, we deal with all of that, wouldn't we? But this is the Crown Court, so get it back to the appropriate Crown Court where it's come from, and let the Crown Court judge deal with that element, whether they're on bail or in custody, but just get them up there as quickly as you can. If it's in the week, so Monday to Friday, would a Crown Court bench warrant come to the Magistrates Court? I think.
Yes.
It's a little bit different because I've just told you, I've just said, oh, if it's a breach of bail, we deal with everything, magistrates, Crown. With bench warrants, it's slightly different because if there's somebody at the police station who's failed to surrender to the Crown Court, if the Crown Court is open, they go to the Crown Court, and it might be that because there is no time limit like the 24 hours. So if you get arrested in Brighton and you've had a warrant that has been issued by Maidstone Crown Court, you're probably not going to get there within 24 hours, but it doesn't matter because there isn't a time limit. So that person should still appear at Maidstone Crown Court, even though they're in Brighton. They wouldn't go to Brighton Crown Court, they would go back to the court where it's been.
So the original court.
The original court. The only time that you might see a bench warrant will be on a Saturday or on an occasional court, which is why you've probably not actually seen one come through, because actually none of you are sitting on Saturdays yet, are you? But it's just really to be aware that, or actually to be aware that if you are sitting in your remand court on a Wednesday and the police are trying to bring you a bench warrant from the Crown Court, you can say, no, we don't deal with them in the week, and you can direct them to get their case, to get that person transported over to the Crown Court. We don't accept people in the week or on a day that the Crown Court is opening. We have to accept them on a weekend or on a bank holiday. So it's only going to be relevant for your purposes on a Saturday or when the Crown Court is Any thoughts or questions on any of the points that we've covered? I mean, like I said right at the very beginning, I think some of this may feel a little bit abstract, but I think once you start doing some observations in the remand court, I think you'll be like, oh, I remember that we talked about, yeah, like, for example, like a breach of bail, oh, it's a Crown Court breach of bail, and it will kind of start to filter through. But I think if you can just kind of keep your notes, and then as you start to work through into the remand court, it will become a little bit more kind of, I suppose, it will drop into place a little bit more. Okay, so as I mentioned right at the beginning, we are going to cover youth remands in the adult court, and you may know this or you may not, but there are going to be occasions where a child, a young person, somebody who's under 18 is going to have to appear in an adult court. They're either going to be jointly charged with an adult, or they're coming in custody as an overnight case, and you haven't got a youth court sitting, because that's the scenario where, oh, sorry, go ahead, Zoe.
You might literally be about to say it.
Oh, okay. So it might be that you don't have a youth court sitting because the majority of courts maybe only have them once a week now. They still have to appear when there's no youth court sitting, and it doesn't matter that you all have not had are not authorised to sit in a youth court. It doesn't matter, because you're not sitting in a youth court. When a young person appears and they are not in a youth court, that young person appears in an adult court, and you sit with adult magistrates. Because actually you might not have any youth magistrates. You might, as just by chance, have youth magistrates, but you don't convert yourself into a youth court. You must sit as an adult court, and what that means is you do not sit as a closed court. You sit as an adult court, because that's what you are. You have to make those reporting restrictions in your court, but you don't clear your court like you would if you were sitting as a youth court. You have to sit as an adult court, and the magistrates have been trained to solely deal with remand. So it's either remand in custody or bail, and you don't do anything more than that. You don't take pleas. You don't start taking pleas and sentencing or anything like that. You literally just progress. You facilitate the case getting from today to the next available youth court, and that's all you have to do. And that's why when you start sitting in the remand court, that might just happen to you, and you might have a young person that's in custody for a breach of bail. It might be that you have a young person who's been charged with a new offence, and the police have brought them in custody. So we have to be able to deal with that, but only for those purposes of dealing with the bail and remand aspect, nothing more than that. So what I'm going to do, just going to share my PowerPoint. Just hopefully this will help, and I'm just going to chat through a couple of slides, and then what we'll do is we'll start to have a look at a scenario, and we can try and work it through as a group. Perhaps we'll role play it out. So we can have someone as the prosecutor. If I just tell you if we just go through very briefly in relation to that. So this is a really important point that is going to be pivotal when you're dealing with youths. There is a statutory duty to consider the welfare of the child in the youth court, and that is a statutory duty that the court has. The welfare, so it's the welfare principle basically. So Children and Young Person Act 1933. It's an old bit of legislation, but it's still good law, and it's still relevant. The court has to have regard to that. The court has to have regard to the welfare, and that's when you're doing anything with a young person, whether it's taking pleas, whether it's sentencing, and if you're considering bail. And what does it really mean when we're talking about welfare? It's things like mental health concerns, learning difficulties, disabilities. There might be all sorts of things that have happened, or that young person is kind of living at the moment. So it's all of those things, speech and language difficulties, because it's actually, I think, one of the greatest kind of barriers in the youth court is participation. It's about language. And although we think about language and how we speak, how we communicate, and the words we use when we're in the adult court, it's even more important with young people, because it's really, the language has got to be so on a level that is understandable, because it's important. And actually, they're potentially, if the court is being asked to remand in custody, the young person's got to understand that and understand why that application is being made. There's actually a really useful bit in the overarching principles in sentencing guidelines as well, and it's sentencing children and young people, and I'll send you a link to it, but it's actually just really helpful in the guidelines. Magistrates have a look at it sometimes. It's just really useful as a bit of an overview in relation to that. Bail and remand provisions. So when you've got a young person appearing before the adult court, it's really important to make sure you've got the right people in court. So what I'm talking about there is the Youth Offending Service. So I think in your handout, I've put a little kind of glossary of terms, because there's loads of abbreviations in the youth court for some reason. So you'll see that they're on there. Youth Offending Service. Remember as well, when you've got a child or a young person who's under 16, there is a statutory requirement that there is a parent or a guardian who attends during all stages of the proceedings. Unless the court is satisfied, it would be unreasonable in all of the circumstances. But the majority of the time, there's an expectation that there'll be somebody with that young person. Now, where do you put the young person in court? If they come in custody, where do you put them in your courtroom?
They come from custody.
If they come in custody,
I
are
think
they in the dock?
in High Wycombe they go in the dock.
I think really they're supposed to actually be out of the dock, and they're supposed to be in the well of the court with their escort. We
have a youth court, but
Yeah.
the reason why I say this is because they will sometimes say there's a youth appearing from custody, we need a secure court. You have a youth court that doesn't have a dock.
Yeah, because I was going to say, most youth courts don't have docks.
Yeah, they don't.
They're almost just like a room like
They're
this.
like a tribunal room.
Yeah, absolutely.
I wouldn't have said that if I hadn't seen messages where they say we need a secure court for the youth coming from custody. So
yeah.
Why move
Well,
them out?
speak to your team locally, but my understanding is that if you've got the expectation is for it that they would be outside the dock. That's how I would deal with it. But
regardless of what they're there for?
because they have got their escort team with them. So, but speak to a team locally. But that's kind of how I would do it. As I said, there is Youth Offending Service. They've actually got a statutory duty to be there and to support young people if they are in court. And so the expectation is they will be there, and if they're not there, you need to wait for them to get there and give them some time to get there, because they're going to be the ones that are going to possibly make some suggestions about bail support packages, or will have some insight into perhaps other factors. They will be potentially the liaison with social services and other agencies that might be involved as well. In terms of starting points, the starting point for a youth is exactly the same as an adult. There's a presumption of unconditional bail. And the Bail Act applies in exactly the same way as it does to adults. And again, the court's got to be satisfied that one or more of the exceptions to bail applies in the same way that you would with an adult. If the court's satisfied, then you would impose some conditions, again, conditions that are appropriate, and that would be the way that you would approach it. Again, you know, necessity, proportionality in terms of your bail conditions as well. Also got, as I mentioned, you've got these, you've got JOS suggesting providing support and suggesting things like bail supervision packages, and so there's lots of different things that they might suggest. It might be that within that they might say they might suggest home visits. It might involve going to school. It might involve the young person reporting to the youth offending service. So it's basically they're looking at doing things that almost occupy their time a little bit and maybe give them some support complying. What about electronic tagging of young people? Is that possible? Is it? Do you think? Have you come across, or anyone thinking about adults, thinking about what we talked about earlier? So a tagged curfew for an adult is
an alternative
to custody, isn't it? So do you think tagging young people, there's a criteria, so it can't just be a suggestion like, oh, there's got to be, yeah, it kind of is the same, and it's actually section 3AA. You can see something that's been inserted a couple of times there. 3AA of the Bail Act, and basically it provides the conditions that have to be satisfied in order that an electronic tagged curfew can be imposed. So just really briefly, and you'll start to, when I read these out, you'll start to kind of recognise some of the phrases. So they've got to be 12 for a start. They've got to be charged or convicted of a violent or sexual offence, or an offence which is punishable in the case of an adult with imprisonment for a term of 14 years or more. Now, is this sounding a little bit familiar when you've possibly had a look at the flow charts, or how for remanding a young person into custody? So it's punishable in the case of an adult with imprisonment for a term of 14 years or more, or have a recent history of repeatedly committing imprisonable offences whilst remanded on bail or to local authority accommodation. So basically, that is the criteria that has to be met in order that a young person has a tagged curfew as part of bail conditions. So it's a pretty high, it's a high bar, but of course it has to be, doesn't it? Because if you're saying for an adult, it's a direct alternative to custody, then for a young person, that bar's got to be just as high, if not higher, actually, hasn't it? Because at the end of the day, remand to custody for a young person is the matter of absolute last resort, last resort. So yeah, that's. But we'll have a look at those kind of tests in a moment. What about a breach of bail for a young person? Is it the same as an adult in terms of the timings and the process? You reckon? Breach of bail for a young person. Yes. Yeah. No.
I don't think there's any reason why it wouldn't be.
Exactly, it is the same. It's exactly the same. So in terms of you've got to be before the court in 24 hours, if the young person doesn't admit the breach, or does the same like mini like little trial of the opinion, again is the test that the magistrates will be deciding upon. Again, if you get that situation, really important thing is to allow the youth offending service time to get there, because often when you're going to be dealing with them, you're dealing with them because there's no youth court, so they're not going to necessarily be in the building. We're going to be like ringing them saying, we've got this case, can you send somebody? So they're not going to be automatically there, so you've got to give them a little bit of time, because again, going right back to the beginning, like the welfare principle, the court has to adhere to that, and part of that will be allowing the youth offending service to get there and give their advice, speak to the young person and find out what's going on. So again, then if it's either been proved or admitted, again you go back. You're in the same position as if you were with an adult, that it's an opportunity to reconsider the bail position. So again, it will either be that there'll be a bail package put forward. The court might say, well, actually, we're just going to re-release on the same conditions, and the case just carries on. If it's a new charge, you need to put it into the next available youth court. If it's like mid proceedings.
What do you mean by a new charge? Sorry.
Like a new charge, like they've come from the police station.
So there was
And
as well as the.
so yeah, you just put it back to the next, whatever the next date is, as well. But so up until now, we're okay, aren't we? Because actually, there's nothing hugely different, is there? Really? What in terms of addressing the young person, what do you call them?
First name?
Yeah.
Do you?
Yes, you do. So whereas like we might be saying, oh, if it was an adult, you might say Mr. Jones, or you'd refer to them in whatever way they want to be referred to. But with a young person, you use their first name, and that's how they're addressed. The difference is where we're kind of coming on to now. So what happens if there is an application to withhold bail, and that's where it becomes different to an adult. So we'll have a look at that, and this is where it is more tricky. Withholding bail, like I said, should be a matter of absolute last resort. What you need to remember as well is you've still got that kind of distinction between summary and prisonable, and either way an indictable offences as well. But the difference with youths is that there is no real prospect test. So there doesn't have to be a realistic prospect of custody, but equally there is then very stringent kind of criteria to get to the remand. So it kind of, in some ways, it kind of cancels itself out a little bit. We're going to have a look now at an actual remand. So the court has to still be satisfied, find exceptions to bail in the same way that you would as an adult. The court then must look for bail conditions. If they think that there are no bail conditions that can be put in place to mitigate the risks, the exceptions that have been found, then they must then consider a remand. But the difference with youths is there's two types of remands. So there's a remand to local authority accommodation, but there is also then a remand to youth detention accommodation. So we'll have a look first at a remand to local authority accommodation. So that's the magistrate's kind of first, if they think a remand is necessary, that is where they have to go. So the minute that they are remanded, I suppose the presumption is that if they're being remanded, they will be remanded to local authority accommodation. So they become a looked after child. However, they're being remanded to the local authority, so it's a refusal of bail.
So they're being put in foster care.
But it will then be for the local authority to decide where they go. And actually, they might go home to their parents because the local authority have decided that that is the appropriate place for them to go. It might be that they go into a foster placement. It might be that they go to another family member. They don't go home to their parents, but they go to a family member. But it's for the local authority to decide that. The court doesn't say where they go because effectively they've become a looked after child. It's the local authority that's looking after them. That's
Duty of care for the over child.
one really important thing to do is if the magistrates do remand to local authority accommodation, you have to make sure that everyone's clear on who the local authority is. And you have to actually, Common Platform will ask you, because then the order will be made out to that local authority. So in court, it has to be established who is the local authority, because sometimes you get a little bit of.
I'm so sorry, this is
Yes.
mind-boggling to me.
No.
So is there someone from the local authority in court when this order is
The
being
youth offending service will
take them to?
tell you who the local authority is. So it will depend where you are. It will depend on the circumstances. You don't have to work it out.
No, I know that. I'm
Um,
just thinking logistically, does that mean that the local authority have a duty person that takes people? Because, I mean, where do they go? The council building?
The youth offending service will sort out like how they get to their placement or how they. So that's part of their role. We don't have to.
So they have all that liaison.
They do that. That's part of their role. We just have to make sure that we say in court who's that designated local authority. So there's nobody arguing. Particularly if you have like split local, in a particular area, you might have like slightly different branches of local authorities. So just make sure that you know who your local authority is. The key thing with the remand to local authority accommodation that sometimes is a bit tricky to get your head around is that it is a remand. It's a remand in custody. So what comes with that is custody time limits. It comes with making sure that the case is listed within 8 clear days. Because even though they haven't gone they've gone home to their parents or their grandparents or wherever they've gone,
They're not in charge of them.
they are still remanded. And it seems a bit of a mad concept in some ways, because we're so used to dealing with adults. If you remand them in custody, they go to prison, don't they? It's quite obvious where they are, isn't it? Whereas for a young person, this first kind of version of a remand is that actually there might be the local authority is going to make that decision. And again, with a remand to local authority accommodation, because it's not a secure remand, the court can also impose conditions. So a little bit like bail conditions. So it might also be that there'll be conditions to do something. So it might be that the youth offending team will put together like a package, like they have to go and report to the youth offending team, and they'll receive some kind of education or something like that. They'll need to go to particular sessions. But again, the youth offending service will put all this together for you. Magistrates aren't expected to kind of think up. It might be that they've got to go and do something in particular. And there's expectation. So actually, if they breach the conditions of their remand to local authority accommodation, that's that breach is dealt with like a breach of bail. That makes sense. So they're remanded and they've got conditions. They're remanded to local authority. They've got conditions. If they then don't do what those conditions say, that becomes a breach. And that is dealt with under section 97 of LASBO. And LASBO is the piece of legislation that's really important to us when we're dealing with young people. So it's the Legal Aid Sentencing and Punishment of Offenders Act. It's a bit of a mouthful, isn't it? But everyone calls it LASBO. So it's section 97, and that's, I have to say, it's only ever once happened to me on a Saturday where a young person has been brought before the court for breach of their local authority accommodation conditions. I have to say the prosecutor did not have a clue what to do with it. I actually thought, I've never dealt with this, I'm not entirely sure. And I had to look it all up and work it out. That's why I know it's section 97, because it's stuck in my mind. But actually, what ended up happening was, because they didn't really know how to deal with it, there were no statements to say what the breach was. It was just that information had been given by the accommodation, so the supported accommodation. They just contacted the police and said this person is not coming back, has absconded from this placement. The police then went and eventually found them and brought them in custody, but there was no statement from anybody. So it was just literally like almost like a bit of hearsay, really, just a bit of. And so how can that be? You still have to deal with breach properly. And so in the end, the prosecutor said, well, I'll have to withdraw the breach, because how can the magistrates be satisfied if there's no evidence? There wasn't anybody there from the placement to say this individual hasn't been coming back and sleeping at the placement. So it still has to be dealt with properly, like you would a breach of bail, and you've still got that whole 24 hours to deal with it as well. So that's a remand to local authority, and that is the expectation where a young person remanded, that would be their status. Now, if it isn't a remand to local authority accommodation, it's this. So it's a remand to youth detention accommodation. So being refused bail, and the court is satisfied that actually the case is more serious and there are reasons it's not suitable to go to local authority accommodation, and they're actually saying it should be a remand to youth detention accommodation. And that's when our flow charts will start to kick in, and that's when you're going to be asked, the magistrates will be asked to consider whether there should be a remand either to youth detention accommodation, either under section 98 of LASBO, and there's a whole flow chart just on section 98, or if it's on section 99, and again, there's a whole flow chart there. So essentially, this is the secure remand. This is the remand to a secure children's home, to YOI, Belton, any kind of actual secure accommodation. So basically, it's like the young person's version of prison, basically. So it's a secure. They're not coming and going like they are on a remand to local authority. They're not going back to live with mum and dad. They are in custody. They are being transported. They are in facility where they're not able to leave when they want to, and that's because it's so serious. That's why there is a really strict criteria to go through, and so basically what the court has to then consider is they have to consider section 98 or 99, and so literally you go go through the flow chart, and actually these are really quite useful flow charts. So you look at section 98. So 98 and 99, kind of the starting points are the same. You've always got to be considering the welfare of the child, and part of that is that it should be a remand to local authority accommodation. And you go through the flow chart. The defendant's got to be aged 12 or above, so you can't be younger than 12. And then you start to go through that flow chart. So it's got to appear to the court that the child is likely to be sentenced to a custodial sentence. So really, we're talking about the much more serious, almost the indictable version of offences that you're looking at. So if you can say yes to that, then is the defendant charged or convicted of a violent or a sexual offence, or an offence that is punishable in the case of an adult with 14 years or more. And that's familiar, isn't it? Because that was part of the curfew, wasn't it? One of the criteria for imposing a curfew for a young person. So you've got to go through. You've got to go through basically through the flow charts, and this is what the magistrates will have, and you've got to be able to say yes to all of those criteria. And as I say, you've got your section 98, and then you've got section 99. So I suppose 98 is kind of more based on the seriousness of the offence and the need to protect the public. And then the other set of conditions is more about imprisonable offences. So essentially, you've got to go through all of those conditions, and you've got to be satisfied of that. If you're not satisfied, so say for example, you don't meet the criteria, is the defendant charged or convicted of a violent or a sexual offence, or an offence punishable in the case of an adult for 14 years or more, if you can't be satisfied, then you have to come back, and it's either conditional bail or remand to local authority. You just can't go any further. If the court can say yes to that, then you move on to the section where you're looking at protection of the public, or to prevent the further commission of imprisonable offences, and you're unable to manage the child in the community. So if you can then say yes to that, then you come down to almost the last criteria, and they've got to be represented. So basically, got to be represented by. They can have duty if they want. They've got to, if they refuse representation, then they have still been offered it. So because sometimes they say they don't want to be represented. Obviously, they've got to be strongly advised to take representation, but sometimes they don't want to be represented. So that's okay if they've refused or they're just not interested, but they have to have been offered that. If they are not represented and they haven't been offered representation, you cannot remand them to youth detention accommodation. So they've got to be represented and able to give their instructions. So what you can do is you go through the criteria of section 98, and then you either will decide that you're going to remand to youth detention accommodation, or you can also still go through the criteria of section 99 as well. So that's slightly different in terms of the test. So you would need to, you'd still need to go through your test there, and make sure that you are able to still satisfy the test that has been put in place under section under section 99. So you've got those same age conditions. You've got to be 12. You've got the sentencing condition in the same way that you've got to be likely that you'll be sentenced to the child will be sentenced to a custodial sentence. And then you've got the history condition. And this is where the court has to be satisfied that there is a recent and significant history of absconding. So that's and it's recent and significant. So again, it's still quite a high bar, isn't it? You still got so it's not just, oh, there's been one occasion of absconding. It's got to be a significant history, and so that's got to have taken place whilst they're either or on bail or remanded to local authority accommodation, and you've also got to be satisfied that the offences that the court is currently considering is one where, taken with previous other imprisonable offences, amounts to a recent and significant history of committing imprisonable offences. So it's actually the wording has been changed because it used to only be amounts to a significant history. They've added recent to the legislation in both parts, again to reflect that actually it's got to be, it can't be like a couple of years ago, it's got to be recent and significant. So again, you've also still got the necessity condition, so it's about remanding, protection of the public as well, and to prevent the commission of further imprisonable offences. Got to be represented in the same way that I just explained as well. So it really is a really high bar, and it should be, because of what the outcome will be of going into youth detention accommodation.
No, I think I kind of overcomplicated it. So when would you use the first set versus the set, or you use the first set then you use the second?
Well, you don't have to. You're not restricted to one or the other.
Yeah.
Most of the time, the prosecution, depending on what the offence is, what the circumstances are, what the offences are, what is the background of the young person,
Yeah.
the prosecution will probably say, and we ask the court to remand under section 98.
Right. Okay.
And so then
That's the texture.
they will then take, like in a normal adult bail application, they will say, and we are applying under because we say that they're going to commit further offences and interfere with witnesses. The prosecution will set it out. It won't be for you and the bench to go, oh, okay, so I've heard all of this. Let's try and fit the pieces into a flow chart.
Yeah.
The prosecution will set it out for you. They should take you through, why is there a recent and significant history of absconding, and they should then be telling you and going, well, actually, this is the evidence, this is the information that supports that.
Yeah.
And so you're getting it from them. But sometimes they might try, if they're not successful on one side, they'll try on the other. But most of the time they will nominate and say why it should be under that. And again, if the court's not satisfied, then you revert back to remand to local authority or conditional bail. But what's really important to note is that if you do remand to youth detention accommodation, there is a legal requirement that the court provides written reasons, which are handed to the young person, to YOS, and to their representatives. So you have to provide written reasons that are shared with them. So it feels really complicated, but I think probably having a go will help, because you'll actually need to go through and have a think about and put some real facts to it. Just before we have a really quick break, I just thought, just as a quick kind of, I suppose, to crystallise a little bit. Right, take one of these, turn it over, and it's just a true or false. Read it out, and we'll decide, is it true or is it false?
So bail conditions which are available to adult defendants are also available for youth defendants.
True or false? True, absolutely. Pass it on. Okay.
If a child or a young person is remanded into custody to YDA,
Youth detention accommodation.
the court can attach conditions to the remand.
True or false? So remember where they're going. Where are they going?
No, false.
Yeah, there's no conditions because
That is it.
that's.
The conditions.
Yeah.
You're going nowhere.
There's no conditions that you're attaching.
When remanding a youth to, I think it's local authority accommodation, the court, it says LLA,
Yeah.
the court can include a condition that directs residents at a specific address.
False.
That's for them to
False,
decide.
that's for the local
It
authority.
is, absolutely.
The age of criminal responsibility in this country at age 10 is the youngest in Europe.
I didn't tell you that. It's, what do you reckon? What do you reckon?
False.
It is.
I think it's 10, but I don't know if it's the youngest in Europe. That's what
Yeah, it is 10.
it is 10, that I know, but
Yeah.
I don't know if it's the youngest in Europe.
True or false? 50-50.
I think it's false.
True.
I think it's false.
It's true.
True.
It's true. Yeah, it's the youngest in Europe. I can't tell you what other countries are, but
It's the youngest in Europe.
we're definitely the youngest in
goodness.
Europe.
I was around when James Bolger was born, so that's why I know the 10.
Yeah, 10 is
Right.
okay. Right, what's your fact? or
When
not?
dealing with a youth in the adult court, the Build Act still applies. Is it true?
Absolutely, it is true. You might have to, I don't know how many cards.
Any child or young person charged with murder must be remanded into YDA.
Now, I didn't touch on murder. So
Say,
have a think about an adult and think about so what are your remand options with a young person?
Either local authority accommodation or YDA.
Yeah.
So it's false because they can
True.
go. It's true. What do you mean?
It's true.
it's murder,
Murder.
which is,
Child.
My
the
child-
adult has no
My
remand.
child kills
I wouldn't-
somebody.
Child,
I think you're supposed to keep it. Right?
Oh,
I would say YDS.
because YDA starts with age 12, isn't it?
Yeah.
So
I think it's false.
what was the wording of it?
Any child.
So any child or young person charged with murder must be remanded. False.
So they must be remanded, but it's for and they must then appear in the Crown Court, but they must be they must be remanded to local authority because it's still a remand. So the
So
court.
that's the
then-
bare minimum.
yeah,
But it
that's
says
the-
YD, but it says into YD.
So it doesn't have to be. It can be.
But it
It
doesn't
can
have.
be. Well, it can be a remand to youth detention accommodation, but as a minimum, it has to be because that's still a remand, isn't it? It's still a remand in custody. So the court has to hear. The court must make a decision. So they kind of have to hear, I suppose, a mini bail application in that way. So there has to be a remand. There's no ability to do a conditional bail, but they must remand as a minimum to. Is it
So
still a
this is
remand?
so this one's false.
Yeah. Yeah, sorry. It's
In its own way, yeah.
In its own
I
way.
don't think it was.
Yeah. So right, go ahead.
When charged with an offence of being in possession of a bladed article, a child or young person may be remanded on conditional bail with an electronic curfew.
False.
When charged with an offence of being in possession of a bladed article, a child or young person may be remanded on conditional bail
What says
with an
maybe?
electronic curfew. I would say it's false.
Why is it false? Because
Yeah.
you've got to meet the criteria which is contained in the Bail Act. So remember we were just talking before, section 3AA of the Bail Act, they've got to be 12, they've got to be charged or been convicted of a violent or a sexual offence. It's got to be an offence punishable in the case of an adult with imprisonment for a term of 14 years or more, or have a recent history of repeatedly committing imprisonable offences. So actually, bladed article doesn't meet the criteria. It's not doesn't get 14 years or more for a bladed article, do you, as an adult? So you've still got to meet that criteria. Although it feels like it's actually an offence which is, you know, being in possession of a blade does feel serious, doesn't it? But it doesn't meet the criteria, so you can't do it.
There's 3 more. Shall we just go back that way or?
Just read them all. So when refusing bail for a child or young person in the adult court, they will be remanded to a prison.
False. Yeah, we know that, don't we? It's not.
Every court when dealing, sorry, do you want to pass it? I was just speeding it. I was just speeding it up. Every court when dealing with a child or a young person shall have regard to the welfare of a child or young person. True. Only a youth court can remand a child or young person into custody. False.
False. The end. There we go. Super. No, well, hopefully that just helps to just kind of just like think about those. Right, let's have a break, and then we'll finish off with our case study that we'll do together, and we can work it out from there. So, if you just are you all right with just like a kind of more of a comfort break, and then we should be able to get through.
Come back up. 3 minutes?
Yeah.
3 minutes.
We just do like back by 20 past. Is that all right?
Let's do